Well, now that we've completed all the paperwork or all the forms and the packets that you need, now we will be going over the end process. And we just completed finishing up all the information that you need for service of process and what to do to serve the other party. So once you've completed all the service, meaning you got your notice or the proof of service back from the courthouse or from the sheriff or the process server, what you need to do now is prepare for the final hearing. And I mentioned that when we were going over the process serving or service of process information and what to do after you get it. But once you get the default and the clerk enters that default, what you need to do is request a hearing from either the judge or what we call the family case manager. And depending on the county that you reside in, majority of them, I would say, have a family case manager that deals with what we call pro se litigants, meaning people that do not have an attorney. However, if your county doesn't have one, you may want to contact the judge that is assigned to your case and see if maybe they're willing to schedule a hearing, or you may have been referred to what we call a general magistrate. So be just considerate of what's going on with your case when you get that final default, because it gives you a specific amount of time to schedule a hearing. If you don't hear anything back from the court, I would say within 2 weeks of you receiving the default notice from the clerk, that's when you need to contact the judge or the general magistrate or even the family case manager. Otherwise, your case may just sit there. But I would say majority of the courts are really understanding of people that are representing themselves. So they will usually take the time and schedule the hearings themselves. So give them that 2 weeks. Don't harass them. Otherwise, they will not like it. So just be aware of that. So once you get a hearing with the judge, you yourself as the petitioner has to be present. However, the respondent does not. So if there's a hearing scheduled and the person you're seeking the divorce from says, I'm not going, do not worry about it. As long as you're there, the case will go on. However, if you've filed what's called a simplified dissolution, or even where you've reached an agreement and filed it together, sometimes, I wouldn't say all the time, they require the other party to be there as well because of the agreement and they want to accept it. They want to make sure you both did it knowingly and voluntarily. So just be aware of that. So once the hearing is scheduled and you get what we call, quote, notice of hearing, it'll give you the date and time and the place of your hearing. So you have to make sure you go to that hearing. Otherwise, if you fail to appear or you do not show, the court may, I say big may, dismiss the case. They may reschedule it, but you as the petitioner or the person seeking the divorce is the one that has to be there. Respondent is not as important, but the petitioner is very important that you have to be there. So once you show up for the hearing, the court will call you in and you go in, and if there's nothing to fight about, i.e. there's no contest or the other party's not contesting it, the court should grant you the divorce, and it will take a couple of weeks before you receive the final judgment, the samples that we provided. Otherwise, if the other party shows up, they're expecting what we call a final hearing. So you have to be prepared with all your evidence. So make sure that you show up with all your evidence. If you haven't gone through mediation and they set it for a final hearing, just make sure you're aware of that, especially if the other party is what we call contesting it and they're saying, no, I'm not going to agree to anything and I'm just going to fight you on whatever you're asking. And so you just want to make sure that you are prepared for a final hearing. If they're not going to hear it right there, they'll give you time and schedule it at a different time. However, they're expecting you to resolve it that day. So once you go through all the hearings, and if the judge has decided, the judge may announce it right then and there. If not, they will send you through the mail a final judgment. And again, it takes a couple of weeks depending on the judge because they have other things to go forward with. So I hope these videos have been helpful to you, and the documents are pretty they're not standard, but they're pretty self-explanatory. Again, if you have any questions, You are free to contact the Community Legal Services of Mid-Florida, and which specific county that you attend, then you may want to contact them, and you could always attend a live workshop. So it's up to you what you do. And I wish everyone good luck, and you can do it. I've had many clients that have completed these workshops and have gotten divorced through this representing themselves. So good luck. And if you have any questions, contact us. Thank you again. Bye-bye.